And sometimes that'll come up in the context of an answer, but it's generally speaking, for all of our commentary here today, it's just general legal information. Remember that the chat function is there for questions or requests for clarification. Please don't provide commentary that borders on legal advice either in there. I think we'll probably have some extra time at the end of today's submitted questions. So if you have questions, feel free to put them into the chat and we will try to get to those at the end. 2 reminders about things that are going on with the WSCAI. There is a fundraiser on May 16th, which is a pickleball fundraiser. As of yesterday, there were still spots for spectators available, and I think maybe even for players. So if you want more information, you can go to WSCAI website, or I don't know if Chelsea has that and can pop it into the chat, the link for that. And then also on June 9th is Virtual Law Day this year through WSCAI. 2 of our attorneys will be presenting at that. And again, go to the website and look for more information on that if you are interested in joining them and hearing what they have to say. Anything I missed, Ken? Anything else to add, or should we just jump
No, I
right
think
in?
we're good. Thanks.
Okay. Our first question that was submitted in advance is, can you please clarify one of the provisions of HB 1500 regarding using third-party providers for resale certificates? What does the language regarding unit owners creating an account with a third-party provider actually mean? Most management companies do use a third-party provider, and this seems like it'd be a huge problem for us, excuse me. The provider we use simply has the requester set up an account with their name and email address, so the information they're requesting could be provided back to them electronically. There's no fee or ongoing obligation for the owner who sets up such an account. The short answer is that what this person is asking about is the changes to RCW 649640 subsection 2C, which is going to go into effect June 11th, so not too long from now, of 2026. And the specific language is that an association may not require a unit owner to contract with or establish an account with a third party in order to provide payment for or accept delivery of a resale certificate required to be furnished under this subsection. It hasn't gone into effect yet, so we don't know what a court will say if someone does object to a provider requiring login or creating an account. But I think I would take the language at its word and look at what the legislature was intending to do. We suspect it's probably because companies were charging a lot of extra fees and things like that when someone was requesting a resale certificate on top of the minimum that the statute required of $275 and passing on other fees to owners. So I think mostly this is probably a restriction on adding on those extra fees that aren't specifically authorized by the statute. I don't know. It might be fine to have a situation where an owner is required to put in their email address and create a password so that you can send them the electronic version of the resale certificate if you're not charging them. But I don't know. The statute does say that they're not required to do that. I would say if an owner is objecting to that, there is no harm, and you should be able to comply with just sending them by email a copy of the certificate if they request it. But again, we don't know. But again, I think this is more linked to the issue about fees than it is about providing a means for sending the certificate to or the statement to an owner who requests it.
Good.
You probably still, if you are needing a rush certificate, I think there's still an ability to do that, those charges. But I think that's what this statute was intending to address. Ken, anything you want to add to that?
I wasn't home yet.
Chelsea, can you mute that?
Yeah, so you can still ask, and my guess is that most owners are going to be willing to provide information so that
Let me
they
see.
can
I
get.
can tell you exactly what time I left because I made a phone call last night.
Okay, the person
We
who's
need
talking
to
right now.
mute
Here it
people.
is. Oops, that's what I meant to do.
Hello, I can't figure out who's not muted, so could you please mute yourself?
Yesterday, 8:07.
Thanks, Denise. So you can still ask owners to sign up in order to receive the resale certificate. You just can't require it. And it actually would be true that you can't require that they accept it electronically, because if they have not agreed to receive notice electronically, then you could still be forced by an owner to send them a paper copy of the resale certificate in order to comply with the statute. I think it would be an infrequent occurrence that someone would require that. So I think it's more a matter of the legislature trying to protect the owners, and I don't know more about it. Second question, if a board member wants an item on the agenda, but the president does not, what options does the board member have in getting on the agenda? So, this may be that you've got a dispute between two board members. It may be that the president is trying to exercise more authority than they actually have as a member of the board. But the answer really comes down to if a board member were to make a motion to add something to the agenda item, then the full board would decide whether or not it becomes an agenda item rather than just the president. So, before the times of having to give notice of all the agenda items in advance to the owners, it was a fairly straightforward process of a board member could simply make a motion for the topic they wanted during the new business part of the board meeting. And if there was a second to the motion, then it could be discussed. And those procedures don't really change. The only real difference I could see is that if you're required to give notice of something to the full membership 7 or 14 days in advance, then probably the best you could do would be to make the motion to add it to the agenda for the next board meeting. And if you get a second from another board member, you vote then as a board whether or not to put it on the agenda. If the vote passes, then it should be put on the agenda and discussed at the next meeting. If the vote fails, then you're basically done. You don't have the support of the rest of the board to deal with that issue. Anything you want to add, Lisa?
No, but I think that segues right into the next question, which is we have a new board member that is determined to add new agenda items in board meetings after the agenda has been distributed to the membership. Are there areas within the updated statutes that outline or limit this ability? So this is kind of a natural add-on, I think, to that question. And so I think what that we're talking about RCW 6490-445 subsection 2F covers notice requirements for meetings that Ken alluded to. There's the 14 days notice for a regular meeting, and then with an agenda that must be provided, and then 7 days for unforeseen circumstances. The agenda as part of that statute is sent out with the notice to all owners ahead of the meeting, and that is intended to be the agenda for the meeting. If this board member insists on adding items, it's possible that, as Ken suggested, a motion could be made at the meeting to add it to the next agenda or to the next meeting agenda, if there's a second to their motion to do that. It's not really clear from the statute whether the board can just add additional agenda items to after the notice has been sent to the owners. The intent of the legislature clearly is owners should know ahead of time what is happening, what is going to be discussed at the meeting, so they're not, surprised, or they, decide not to attend a meeting because the agenda items don't look like something they need to be concerned about, and then the board puts something on the agenda, or someone puts something on the agenda that they weren't expecting. There is a provision that says that board actions are valid regardless of compliance with the statute if they're not challenged within a specific period of time. It's 90 days of notice of a decision. So there's that sort of out, I guess. Whether you allow a new agenda item could be dependent on what Ken was talking about before, whether there's a second to the person's motion to add the item, and it could be a question of what the motion is about and what risk there is if you don't give owners notice of that ahead of time. And so I think you're looking at a balance of what did the legislature intend here, and how easy and how realistic is compliance by the board to that, the goal of the legislature. Generally speaking, we're looking, for the board to act in good faith and to substantially comply as best they can with what the legislature intended. Anything you want to add to that, Ken?
No, I want to echo that, acting in good faith and attempting compliance I think are really things the board should be working on, and that that there's always been procedural failures by community associations. I mean, for decades, people just don't even remember what's in their documents, and they don't remember how to run things. And communities get along for decades functioning just fine. And so part of it comes down to whether or not you've got problems in your community where people are going to start challenging procedure because they don't like the decisions that you're making. You know, if you're looking at an increase in assessments because of a project, people are going to make sure that you have complied strictly with all of the statutory requirements, or they're going to challenge it. And so if you've got problems, then start complying more precisely with the statute. If you have a mostly complacent group of owners who are indifferent to what the board is doing, then how you comply is not going to be particularly relevant. And it is a balancing act of, you know, how much effort you put into compliance if no one cares. But you do have to recognize that there is a risk that someone's going to come back after the fact. And I think the 90-day timeline the legislature put in for challenging the board's process was a concession on the part of the legislature that boards are trying to take care of their members. And so all their decisions shouldn't be thrown up and questioned years after the fact. Next question. In hopes to have our governing documents reviewed for recommendations to changes to be in compliance with new laws, how do we know where you've covered everything? So I guess we're interpreting this question to relate to how do you know if you've found everything in your governing documents that is changed from the law? And of course, you can hire an attorney to review your documents and tell you where there are conflicts. The biggest challenge we have, because we've done this for a number of clients, is that there are many things in WUCIOA which are optional. So your documents may not have any reference to the issue. So, for example, whether or not you can charge owners for misconduct is something which is allowed in WUCIOA, but it's not mandatory in WUCIOA. So if your existing documents don't discuss it, there's nothing to change in your documents. It's still in compliance with WUCIOA. But if you wanted the benefit of being able to assess costs to owners for failure to maintain their property, then you would need to adopt pieces of WUCIOA. If you're looking to just become WUCIOA compliant, it is possible for the unique things about your property to be put into a sort of standard WUCIOA compliant set of CC&Rs or condo declaration. And we've also done that for some clients where you're not looking to do anything except, eliminate the conflicts from your document. It still requires a vote of your members, but it is a way to deal with it. And, how do you know you've covered everything? I guess it depends on the level of trust you have in the consultants that you're hiring. And it depends on your ability to read through the documents yourself. One thing we now do is we actually cite the RCW numbers in the restatements that we do to make it easier for owners and board members to confirm that the changes that we put in the new document actually do match up and align with the statute. And it's also to try and eliminate some of the questions where, owners say, well, why are you doing that? Why does the association have the right to enter my lot? And the answer is, well, the statute gives the association the right to enter the lot for these specific reasons. And so I don't know if you want to add anything else on that, Lisa.
Nope, I think I'll just go to the next question. The next question is about recording meetings, and the person asks, can't recording have a chilling effect on homeowner participation? So since some people will not feel comfortable being recorded, wouldn't an owner who doesn't consent to being recorded effectively be excluded from the homeowners forum? And the first thing I would say is there's no requirement to record meetings. So we don't really know what the purpose for this particular association is for recording meetings. There is no requirement to. But I suppose if you do elect to record meetings, sure, that could have a chilling effect on owners. They may choose not to talk, and that obviously would be a byproduct of recording those meetings. I would also mention that if you're interested in or thinking about recording meetings, we have discussed this topic a lot. So if you search recording on our YouTube channel, you can come up with a prior discussion about that. We've talked also about sort of the expectation of privacy that people have. There's really very little expectation of privacy you have. So if an owner is concerned about being recorded, I mean, someone could be secretly recording the meeting and they wouldn't know about it, and they could be caught on that recording. I don't know, I don't think there's any study that I've seen about whether this is, affects owner participation or not. But I think that the short answer is sure, it could chill homeowner attendance or speaking. But again, I guess I'd ask, why are you recording the meeting? Because it isn't required. Anything you want to add, Ken?
No, I'm good.
Okay.
So the next question is, how long has mediation been a requirement in small claims court? And so we think it's been at least 10 years. I know that 25 years ago when I was in law school, it was an option. And somewhere between then and 10 years ago, all of the district courts made it a requirement. And in fact, now when you are first scheduled to show up in court, it is for the mediation, not to have your matter heard by a judge. And this does disappoint a lot of people because they think they've got their day in court and instead they get to sit with a mediator and discuss it with the other side. The process for small claims court, it's easy to file, it's cheap to file. If you're the defendant, you're sort of stuck with having to participate because there's not really a way to defend yourself in advance. We know that some clients have mandatory mediation and arbitration provisions in their governing documents, and that would be an absolute defense in small claims court, is that the decision, the dispute has to be resolved by mediation and arbitration, but you don't get to have that conversation with the small claims court judge until you actually are appearing in front of them. You can't write them a letter in advance and explain it. So I guess that's the short answer, is a long time. Anything you want to add, Lisa?
Just one thing that, attorneys don't typically practice in small claims court. So sometimes in a collections matter, we will recommend, if the amount owed is under the jurisdictional limit, that an association or their management company file a small claims action to resolve an issue. And it is critical, as Ken said, not only for the defendant to show up, but for the plaintiff to show up. If you don't show up, you run the risk of having your case dismissed with prejudice, meaning you can't file it again. So I would, if you're going to do small claims, make sure you read the information on the court's website and follow the procedures closely. Okay, next question. Are HOAs required to put every expenditure to a vote in a board meeting? Are there any exceptions for urgent situations or budgeted expenses? What qualifies as a ministerial action? And can the HOA amend its governing documents to expand the definition of a ministerial action? And then they ask, how many meetings are boards required to have each year? So the first question is about expenditures. And I think, generally speaking, that's what your budget is for. The budget and the ratification process tell owners where the money is going to be used in the coming year. But I guess the question is what are you asking? Are you asking every time a check is written, should the board approve those expenditures? So you're paying the landscaper, you're paying cable, whatever the thing is. I don't know. I mean, certainly the safest thing to do would be to do that, is to have the board approve all expenditures, but that's typically not practical in most associations. I think management, as long as the expenditure is something that is an approved expense under the, by the board as far as the budget goes, the management typically, writes the checks every month to the ongoing expenses. I suppose if you're asking, if this is an unbudgeted expense, like a special assessment, should that be done to board meeting? Yes, a special assessment needs to be done just like the regular budget with the notice provisions that are outlined in the statute, and we've had discussions about that before. If you're talking about urgent situations, yes, urgent situations could fall into the emergency meeting section of RCW 649502. It defines what an emergency is, and that applies to all associations. So there are exceptions there is a statute, for that specific question. Ken, before I go on to the next question, did you want to add anything on expenditures?
Well, I was just going to offer that the legislature didn't do anything to clarify the delegation of board authority to management companies. And so we know a lot of management companies have contracts where they are delegated specific levels of authority and they can approve bills and things, but none of that is actually contemplated or referenced in the statutes themselves. We have not seen court cases challenging that, but it certainly has the potential. And, theoretically, boards are responsible for everything that happens. So if the management company is doing things, they should want to know.
Right. The second part of this question was, what is a ministerial action? And as we have discussed a few times since this has come up in the statute, we don't know for sure because it's not a defined term. And if you have specific questions about something you're doing and whether or not that is ministerial, that is certainly something you may want to talk to your counsel about. But we think actions that comply with established policies and procedures could qualify. So if you have a policy for investment decisions for your reserves, payments of recurring utility bills or service contracts, fine enforcement and collection policies, or expenditures that are included with your budget, those potentially could qualify under a ministerial action. So for example, if an owner requests a payment plan and waiver of late charges and interest, if the board has a policy on how they handle that type of request, that may be something that is considered a ministerial action and not required to be initially decided at a board meeting. It may be that you ratify that decision at the following board meeting, but that may be something that qualifies as a ministerial action. But again, because the statute does not define the term, we're using our best, not guess, but our best thoughts on what that may mean. Anything you want to add to that, Ken, before I go on to the third question?
Just that when we are trying to define it more precisely, we do look to the RCW, and there are ministerial acts defined for government officials. And so we borrow from that to try and justify decisions for our clients.
Okay, the third question was about how many meetings are boards required to have each year. And if you look to RCW 6490-445 subsection 2D, it says that during declarant control, the board must meet at least 4 times a year. And then after the transition meeting, the board should meet according to their governing documents, which is often found in their bylaws. But neither WUCIOA nor the Nonprofit Corporations Act set a minimum number of meetings per year. So make sure you look to your governing documents. Again, often your bylaws, they may say that the board must meet monthly or quarterly or whatever the thing is. So make sure you're complying with whatever your specific set of documents has as a schedule, if there is one. And then you also just want to generally make sure that the business of your association is getting done. Because of the changes to the meetings requirements, you need to make sure that you are having board meetings often enough to make those decisions and have those conversations and make those motions. And often, I'd say a number of our clients meet either monthly or every other month to make sure that the work of their association gets done. Anything you want to add to that, Ken?
Well, just again, you're trying to balance compliance with the efficiency of keeping things going. And, we know that many of our clients are still having discussions and taking votes via email. And again, the risk associated with that will be very dependent on the particular decisions being made. If they truly are emergencies, you have a lot of discretion to meet and to make decisions even without a quorum of the board. And, most decisions made by boards don't have the risk because no one cares about what is going on, but it is a requirement. And again, we don't know why the legislature sort of got on this horse and started pushing it to require much more transparency. We just know that's how the statute's written today. And I think that the CAI Legislative Action Committee is planning on trying to introduce some legislation to clarify what ministerial acts are and to give boards back some flexibility to conduct business via email. And that's, if you had input you wanted to provide for that, then you should reach out to the Legislative Action Committee through CAI. Next question. I'm curious, since new laws are mandatory on January 1, 2028, does that mean no vote from the owners is needed? And the short answer is that's correct. No action needs to be taken by any association when the new statutes are fully effective on January 1, 2028. It's not going to change the text of any of your documents, but to the extent there are conflicts, those statutes control over your documents. Anything you want to add, Lisa?
Nope. I will just go on to the next question. The next question is about smoking. This person is asking if the notes that they made after our last conversation are correct, and that smoking is not considered a nuisance in Washington state, that an association does not have the right to restrict smoking, and that you need your declaration in or any amendment to address this and assistance with your association counsel. The short answer is, or there's a couple answers here. There is an appellate court decision that says that cigarette smoke is not a nuisance under Washington common law. That case was about 13 years ago. But that defines what a nuisance is, or whether this is a nuisance under common law and not the governing documents for your community. So you could, in theory, talk to your association counsel and draft your an amendment to your governing documents that says that cigarette smoke is a nuisance under the permit, in your community. And when we update declarations for our clients, we will often define smoking specifically to be a nuisance. So that is one way to address that issue. This question might, about restricting smoking may depend on what kind of community you're in, because there aren't any laws that say you can't ban smoking provided that you're following the appropriate steps. And for most communities, banning smoking community-wide, is going to require declaration amendments, not just putting up signs or something like that. If you're just talking about common areas and limited common elements, that's possible. You can probably do that by a rule, by a board vote only, and that's because the association is allowed to regulate the uses of, via the board, the common elements and limited common elements in your community. Again, talk to your association counsel if you have concerns or questions about how to do that. But if you're looking to ban smoking entirely from your community as a whole, that is probably, yes, going to require an amendment to your governing documents, to your declaration, CC&Rs. I think that's about it. Ken, anything you want to add to that? This is something you...
I think you covered it pretty well.
Okay.
Question 10, should we as a board request a hold harmless agreement if an owner wants to make a repair to something the association is responsible for? For example, replacing a gate post at their own cost. We have no policy and procedure for this, and these owners' repairs have been allowed in the past without a hold harmless agreement. So we are unclear on what you're actually asking about here and what you mean by a hold harmless. So if you're asking about the risk to the association of the owner performing work that the association is responsible for, usually I would look at this as a question about, volunteer liability. And so we would normally say, well, if you're going to allow owners to be performing work on common areas as volunteers, that you look to your insurance company to make sure you are covering insurance that would protect the volunteer if they are hurt while they're doing the work, and insurance to protect the association if the volunteer causes damage. Because those are really the risks that concern me most. Is, the equivalent of a workers' comp claim because a person is injured while they're working, or an owner happens to damage part of the building because they are, performing the work and something happens. So those are risks that would not have much to do with a quote hold harmless agreement. We have helped a number of clients draft volunteer agreements, which basically state that the person is volunteering and that they are assuming the risk of injuring themselves and that they are, willing to defend the association if there's any claim brought because of their injuries. Those are certainly, I would say, good ideas. They're not necessarily going to be binding because some courts are going to find that the volunteers were, not making informed consent when they signed them. But if you're going to have a regular practice of allowing owners to volunteer and perform work, then it is reasonable to adopt some kind of policy or procedure which would discuss how you're going to address those risks. Anything you want to add, Lisa?
No, I'll just go to the next question. Does RCW 649445, subsection 1A, which says that a meeting of the association must be held once a year, supersede the language in an association's bylaws that specify that the annual meeting shall be held in the first quarter of the year? Could the association instead hold the meeting at any other point during the year if that is appropriate? Certainly, I'm not looking at your governing documents now, so this is not intended to be specific legal advice for you. But the statute requires one meeting per year, and your governing documents might say when that one meeting per year happens, and that is not a conflict. So there is no, I wouldn't say that the statute needs to supersede that language, because holding a meeting once a year just means have it at one time per year. And if your governing documents specify what time during the year that one meeting is held, that is not in conflict, and then that therefore would be an appropriate restriction for your community, for a community. So if the bylaws say that meeting has to be held in the third quarter of every year, and that's annually, and you're holding it annually, you should hold it in the third quarter of every year. It doesn't, the statute wouldn't wipe out that provision because it does not conflict with what the statute says. Anything to add to that, Ken?
No, just, it's a good example of something that's allowed by WUCIOA, not required by WUCIOA. And so if you want to change it from holding the meeting in January, you need to amend your bylaws. Next question. Our management company has not proactively advised the board on compliance with RCW 649445, which is the open board meeting and committee meetings section. We have a few questions. First is the 14-day notice requirement. Do you recommend scheduling board meetings together and committee meetings together on a regular basis and providing advance notice of the schedule to owners with a generic agenda? And absolutely, we recommend that, because that is the easiest way to avoid having to send out a lot of notices every time you want to hold a meeting. It also gives some predictability to your members, so they should know if they're sending something into the Architectural Control Committee, what the schedule might be for it to be heard. Meeting materials. Do you recommend posting meeting materials distributed to the board on an owner's portal to meet the reasonably available requirement? Do those need to be available prior to the meeting? So I would say that yes, posting the board material on a portal would certainly qualify as reasonably available. You need to be cautious that you're not including some material that would be normally withheld. So something which was related to contracts in negotiation or related to enforcement or collections, if those are not being, or if those are going to be discussed in executive session, those should not be put on the owner's portal. And I think that the legislative intent is that if the material is available to board members in advance of a meeting, it is also available to a requesting owner. I do not think it would meet the legislative intent to post the board packet 2 days after the board meeting, because then the owner does not have an opportunity to comment before the board has conducted its business on that matter. Okay. But you're not required to post this material. You are only required to make it available on request. Third one is voting. If our board or committee meetings are held via Zoom, are all matters voted on required to be done in open session, including executive session matters? So the short answer is that yes, all votes done by the board or a committee exercising authority of the board have to be done in open session. The executive session is generally for discussion by the board, not decision making, and the statute actually says that you don't make decisions in executive session. So if you went into an executive session to discuss a fine and enforcement matter and try and determine how much of the fine you're going to assess, then you would come back into the open meeting and someone would make a motion in order to have on the record the decision of the board. Next one is emergencies. Would plumbing leaks, power outages, or fire alarm outages constitute emergencies for the purposes of RCW 6490-502? And my short answer is yes, I think they would. Anything which requires immediate attention, I think will qualify under the definition provided in the statute. So if you've got an active plumbing leak, I think you can use the emergency provisions to get the leak stopped and to take care of anything which is causing immediate damage. As soon as you've taken care of the leak and you've taken care of mitigation to stop immediate damage, it stops being an emergency. So the repair would have to be done using your normal process. What owner's notice is required for board to take action by email to address an emergency? So the notice provision in section 502, I think states you are supposed to provide notice in a manner which is practical under the circumstances. So if you had your fire system go down and you need to do an emergency fire watch or something, it is certainly practical for you to send an email to all the owners. If you had text messages, you could do that. It may even be reasonable in some cases to go door to door, knocking on doors, advising owners of emergency situations. But it's really going to depend on the particular circumstances. If you had something significant like a fire occur, then basically the board members who are there start to make all the decisions on their own. The statute even says you don't need a quorum. If you can't get one reasonably, you just take care of it. So did you have anything else you wanted to add, Lisa?
Nope. That was our last pre-submitted question. Chelsea, do we have any in the chat that we should talk about or can talk about?
All right, so first chat question is, if the annual meeting calendar has been provided to owners and the board wants to flesh it out for each meeting, sending a final detailed agenda a few days before the meeting seems like a courtesy and makes sense since things come up quickly and need attention. Not 2 weeks or 7 days. 3 days works well for us. We're trying to comply, but also inform owners. So that sounds more like a comment than a question. But if you guys want to add anything, go ahead.
I think that fits in with exactly what Ken was saying before about doing your best to comply with the statute by sending out the meeting agenda. But if something comes up that you need to flesh it out, providing notice to your owners is.
And it will depend a little bit on what the particular topic is. We certainly have a number of clients we know that are sending an email out, I think 3 days in advance of the actual meeting to inform owners of the final agenda. And I think that that's a relatively low risk thing for them to do. It is substantial compliance, and they have not had any owners complain about it, which is also helpful. If you were going to do a new agenda item about a rule, though, or changing your fines, I think that a different section of the statute requires that you mail that or give it in the form of notice as an owner has agreed to every owner in advance and provide a opportunity to comment. It doesn't say how many days for that opportunity to comment, but I would say you shouldn't go less than the 14 that is required for notice of an agenda item before you actually discuss that at a board meeting. So, minor things, I think, like, violation challenges, or, people appealing violations, architectural control questions. We believe for the most part that those are going to be sort of a generic agenda item that you're going to put on every time. And if you could inform people of the specific, architectural request maybe beforehand, that would be helpful, but probably not necessary in most cases. Again, until we start getting some court decisions clarifying exactly what the legislature meant, we're not going to be able to provide more guidance than kind of a best educated guess on how courts have interpreted other sections of the statutes in the past. Anything you want to add, Lisa?
No, that sounds good to me.
How specific does the agenda need to be? Some boards publish an agenda that simply has call to order, financial review, approval of minutes, old business, new business, adjournment. Is this allowed under the statute, or are boards required to give specific topics of discussion?
Well, I wish we knew. I wish the legislature had provided more guidance. I think just saying old business, new business is not going to meet the intent of the legislature. Because if you've got old business, you know what it is. You should list it. If you've got as old business something about the landscaping or removal of a tree or adoption of a policy for investments or anything else, you should list it under the old business. If you've got new business and you know what it is in advance of the meeting, I would list that too. The idea is that the owner is supposed to have some idea of what you're going to discuss so they can make an informed decision about whether they want to attend the meeting or not. So if you are not telling them anything that's going to be on the agenda, you're not giving them a fair opportunity to know what you're going to discuss. And this kind of gets back to, if you're going to change the rules about cats and you didn't tell them you were going to do it and give them the proposal in advance, and you do it at a board meeting where it wasn't on the agenda, I think you're at pretty high risk it's going to be challenged.
Any other questions, Chelsea?
All right. What are the compliance options for a fully non-smoking HOA against an owner that states they are not smoking in their unit, but others can smell it? Other than smell, no physical proof has been found. We had a forensic team in several months ago, and no nicotine was found present in their unit.
Well, this, I think, is starting to get too specific for our forum. The general rule is that if for any kind of enforcement complaint, and one owner typically is complaining about another owner, the board has a duty to investigate in order to try and find a violation. If you brought in a consultant and could find no evidence of a violation, then the board would have to basically say to the complaining owner, we can't find any evidence of a violation, and so we cannot take any other enforcement action. Under 6490, I think it's 405, subsections 7, 8, and 9, the board has the discretion to decide when enforcement is appropriate or not. And so if you have made some effort to determine if there's a violation, can't find a violation, then just inform the complaining owner and choose not to enforce further. It's also something where, individual owners are going to complain that the board is not enforcing. And I try and remind owners that they also have the authority to enforce the governing documents independently. They do not need the board for an owner to sue their neighbor for smoking if there's a violation of a no smoking provision in your documents. And if the board can't do it for you, then you have the authority under the statutes and under almost every set of declarations to do it yourself. I would normally look also for an arbitration provision to see if there's one in your particular documents, because that would be sometimes a mandatory alternative to a lawsuit. Anything you want to add, Lisa?
No, I think just that we talked about the duty to investigate maybe 2 months ago. So if you look on our YouTube channel, there's a more complete discussion of that topic.
And there are some kinds of complaints, noise ones in particular, where it becomes virtually impossible for the board to experience and find that there's a violation. If you're complaining because your upstairs neighbors are tap dancing on the floor, but every time the board comes to investigate, it's quiet, the board really can't do much for you. Anything else, Chelsea?
All right. Do you have to notify about the meeting directly after the annual meeting to select board of directors?
I think that if your governing documents state that the first meeting of the board is immediately following the annual meeting, you would not need to do anything more. But I also think it would be easy to stick on your notice of the annual meeting that at the conclusion of the meeting, the board would meet in order to appoint officers. So I would say, well, the safe thing to do is just list you're going to have a board meeting following the annual meeting in order to appoint officers.
All right. Follow-up question about smoking. Does this also restrict smoking inside an owner's unit or only common areas?
And that'll depend on how your documents are written. The general rule is that the board can regulate the use of common and limited common elements, which would normally include decks and balconies. But unless the declaration provides specific authority to regulate the interior of the unit, the board can't do that.
Okay. What are the ramifications on associations and owners if the provisions of RCW 6450 are not adhered to? Are associations obligated by statute to make known maintenance repairs in a timely manner after receiving insurance settlements for maintenance repairs?
I don't remember 6450 being about maintenance and repairs. I thought it was about reserves.
Construction defect claims, I think they're asking about.
6450. Yes, that's true. That is the notice provision where you have to give notice to a construction professional before you can proceed with a lawsuit. This is very specific to what is claimed in the notice of construction defect, what is proven, and then what amount of money you get, essentially. So without giving any legal advice on this, I would say that, having done construction defect litigation for more than 25 years, I almost always advise clients that the claims that you make in the claim and litigation process are going to be different than what you would perform if you were spending all of your own money. And so I will frequently recommend that you have a reevaluation of the construction done following conclusion of your litigation or settlement or insurance process. to reevaluate based on the values of the community rather than trying to apply what might be an applicable legal standard and the values of your construction consultant. It's not quite the same, but I was sent information from a client about mold found inside attics in a townhome community. And all the owners are upset because the contractors who want to come out and charge them about $6,000 a unit to clean out the attics of all the insulation and spray mold retardant and then refill the attics with insulation are very excited about getting paid to do that work. And they are claiming that there's all kinds of toxic mold in the attic spaces, which must be replaced. And I'm looking at the photographs, and there's virtually nothing in the photograph I can find as would deviate from standard construction. And so I have to tell the client that you need to find a more objective consultant, not the contractor who wants to make money off of doing the work, to evaluate the claim. And so it may be that you need to reevaluate your buildings based on what your community values and how much money you have, rather than based on what an attorney or a construction consultant was willing to put down on paper as requiring work. Because the purpose of the litigation in that claim is to maximize the amount of money you get, not to make the buildings whole. It is purely focused on money. And so once you've got the money issue resolved, you need to then reevaluate the buildings and look at what needs to be repaired. All of the documents that were prepared during the litigation are still going to be available to owners. And it may be that you need to have new evaluations done where the standard, instead of it being this is a construction defect or not a construction defect, is one where the consultant helps you evaluate the level of risk associated with accepting and living with the construction as it is built. So this is something that requires a lot of in-depth analysis of what the claims were and what the alleged defects are. But I would say in almost all construction defect claims and insurance claims for things like wind-driven rain, there is not enough money to do what the consultant said that you should do during that process. So you either need to collect more money from your owners, or you need to revise the scope of work to be something that you can manage instead of having it new. So I don't know if you've got anything to add, Lisa.
No, I'll leave that one to you.
Is there anything in 6434 that currently requires accrual accounting other than 6434 42511? We are self-governed and our treasurer uses cost accounting.
Well, the accrual accounting requirement is there, but it's not all the time. It says you're supposed to do accrual accounting, I think, at least once per year. And I think that also is a requirement in there that you have to get a CPA audit unless you are under 50 units and you have waived that audit requirement. Under 6490, they have changed the audit requirement effective June this year. So if your budget is under $100,000 a year, then the community is allowed to vote to waive the audit. But the accrual accounting is still required there. But again, it's not that you have to do accrual accounting all the time. You just have to do it at least the one time per year as required by the statute.
When considering board approval for maintenance items, if the budget has a section for maintenance, can the board approve maintenance items outside of a board meeting? Can the board approve maintenance items that go over the budgeted amount?
This is the same question as, is it a ministerial act? And there is no clear guidance. If you were to adopt board policies which were to clarify that expenditures within your budget or within a certain range, or expenditures which were to stop leaks or to eliminate safety concerns should be handled as ministerial acts, then I could probably support that. But I can't just support a blanket idea that, oh, it's a maintenance item, it can be done outside the board meeting. In order to convert it to a ministerial act, you have to have some guidance which takes away the discretion of the board in how the decision is made. That's why things like collections policies are fairly easy to read as ministerial acts. Because if it says a collection matter will be forwarded to an attorney when it's 90 days delinquent, the board could vote by email to send it after it's 90 days delinquent. Because you have a policy, it doesn't require discretion in the analysis by the board.
If it seems likely that a special assessment will be needed due to underfunded maintenance reserves and a legal inquiry is being considered to attempt insurance recovery, how much information must be disclosed to owners about the status of these plans?
You have an attorney involved in an insurance claim, I think you should be asking the attorney who is handling your insurance claim. In terms of disclosure about just poorly funded reserves, the reserve study itself should include all of the analysis that is necessary to advise owners about the adequacy of your reserves. And if the consultant believes you're going to need a special assessment, it should say so right in the reserve study. And as part of your annual budget process, you are required to tell owners how much of a deficit or surplus there is in the reserves. And you are required to tell owners if there is a current reserve study. So I think that the legislature has built in a number of notice requirements that you're supposed to take care of. So an owner who's paying any attention at all would be well informed about the risk of a special assessment coming up. Anything you want to add, Lisa?
No. We're just about done here. Don't see any other questions. Are there any ones directly to you, Chelsea?
Mm-mm.
Okay. I think with that, thank you very much, everyone, for being here today. And we will, some of us will talk to you next week. Thanks for coming.
Right.